Good morning. I am Dr. D. Anita Kumari, Associate Professor, School of Management Studies, Vistas. In today's class, we are going to discuss about MOA, that is Memorandum of Association. What is MOA? That is Memorandum of Association. It is a document to be submitted at the time of incorporation of a company. Each and every types of a company required to be compulsory registered under the provision of Companies Act 2013. At the time of registration, the company have to present some document for the basis. There are three basic legal documents issued by the company. These are Memorandum of Association, that is called MOA, Articles of Association, Prospectus. The first step is the formation of a company is to prepare Memorandum of Association. This is also known as a constitution of the company. A Memorandum of Association MOA represents the charter of the company. It is a legal document prepared during the formation and registration process of a company to define its relationship with the shareholder, and it specifies that objectives for which the company has been formed. The company can undertake only those activities that are mentioned in the MOA. As such, the MOA lays down the boundary beyond which the actions of the company cannot go. Meaning and definition. Meaning: MOA is a fundamental document of a company which determines the era of working company. The objectives of MOA is to provide the information about the objectives of the company to the shareholder, creditor and other person having relationship with the company. Who are the other person? Maybe the client, maybe the creditors, maybe the investors. So with the help of the MOA, the members who is related to the company, they could able to understand what kind of a process is going on in the company. Thus the MOA is a very important document which indicate established with having specified name, situated in particular state, having fixed share capital with definite liabilities of its members and specific objective. The Companies Act 2013 defines MOA of a company as originally formed or as altered time to time in pursuance of any provisions. The Companies Act 2013 defines MOA of a company as originally formed or as altered time to time in pursuance of any previous company, law or present act. These are the contents of MOA: name clause, registered office clause, object clause, liability clause, capital clause and subscription clause. Let us see in detail what is called name clause. This section determines the company's name. The company's name should not be same as that another business. Even since it is a private entity, the term private limited should be included at the top. So if the company is private company, the company name should end up with PVT Limited. Whereas if it is a public limited company, the company name should end up with a limited. Situation clause. Every company shall have registered office from the day on which it begins to carry on the business, or as from 13th day after. Every company shall have a registered office from the day on which it begins to carry on business, or as from the 30th day after the date of its incorporation, whichever is earlier. All communication and notice are to be addressed to that registered office. Notice of the situation of the registered office and every change shall be given to the registrar within 30 days after the date of incorporation of the company or after the date of change. If default is made in complying with these requirements, the company and every officer who is in default shall be punishable with fine which may extend to ₹50 for every day during which the default continues. Object clause. Great care should be taken in drawing up this clause, as company will not be allowed to do any business which is not specifically mentioned here. So this is an important clause. As it is difficult to alter object clause later, it is necessary that promoters should include in this class all the possible types of a business in which a company may engage in the future. Although it is best to state all the power in addition to the object class, yes, if the company does anything which is incidental to and consequential upon the power specified, such an act will not be an illegal. Thus, a trading company under its implied power, through not mentioned in the object class, can borrow, draw and accept bill in the ordinary course of business. Liability class. This class has to state the nature of liability that members incur. In the case of a company limited by share, the members are liable only upon the amount paid on the share taken by them. In case of a company limited by guarantee, the members are liable to the amount undertaken to be contributed by them to the assets of the company in the event of its being winding up. The liability class is omitted from the Memorandum of Association of Unlimited Company. Any alteration in the memorandum compelling a member to take up more share or which increase his liability would be null and void. Capital class. The memorandum of a company limited by share must state authorized or nominal share capital, the different kind of share and the nominal value of each share. The capital of a company may be divided into share of two different classes, namely preference and equity share. A company under section 95 of the Act may alter the condition of its memorandum with respect to its share capital by ordinary resolution if authorized by the article. According to section 100, a company limited by a share or a company limited by a guarantee and having a share capital may reduce its share capital by special resolution if authorized by the articles and confirmed by the court. Subscription class. Subscribers to the memorandum express their assent to form a company and signify their agreement to associate for that purpose. The memorandum has to be signed by each subscriber in the presence of at least one witness who must at least the signature. Under this class, we have declaration of the association which is made by the signatories of the memorandum. Under this signature duly attested by the witness that they decide to be formed into a company and that they agree to be and that they agree to the purchase of qualification shares. There must be at least 7 signatories in the case of public company and at least 2 in respect of a private company. The subscribers usually act as a first director of the company. In respect of company which is limited by a guarantee or is having unlimited liability and which has no share capital, the legal provision regarding the purchase of at least one share by each subscriber does not apply. So in this class we have discussed what is called MOA, what are the various contents in MOA. So this MOA is a very much important content to be submitted at the time of incorporation of a company. Thank you.